A very good evening to all my dear students. I welcome you on behalf of ICAI for this session, that is second session of foreign companies incorporated outside India. So I hope the excitement is mutual at that side also. The way I'm excited to teach you, and your good evening and beautiful wishes have made me realize how eager you have been waiting for this lecture today. Good evening, Nanda Goel. You have sent me query also. Hardik also has sent me a very long query. I'm going to read it in a while. Preeti Kumari, Lahari Moruju, Nancy, good children, you had a query because you have been revising it. Then only that's why you have come across certain queries. So that's great. Well done. Good evening, Pallavi, Neeru, Mahi, I'm fine. I hope you all are also doing good. Ritika, Ragini, Sanya, Balesh, Rashmi, all those who have joined. Tambeshwari is asking about ultimate beneficiary. So the same one that we have discussed in chapter number 3 and 4, where we were doing share capital and debentures, the same definition applies for the ultimate beneficiary here as well. Good evening, Sukhveer, Pranav, Vaishnavi, all of you. Welcome for the class. And I hope you have revised your foreign companies, the previous lecture that we have done. So let me read out the query raised by Nanda Goel, first of all, which is related to your foreign company. She has written, ma'am, there is an Indian company having foreign subsidiary. That foreign subsidiary renders services to India. In this case, Indian company is deemed as foreign company or a foreign subsidiary. So why don't the class answer me this question? It's a very interesting question that Nanda Goel has raised, and I put it across to the class. You can answer me in the chat box. So it is a very clear-cut question, Nanda, where it is written when there is an Indian company having a foreign subsidiary. So children, tell me, can we call it a foreign company first of all? Let me see who answers the first. No, ma'am, is the correct answer. It will never be a foreign company, child. Why? Because a company incorporated outside India is the mandatory condition. So section 2, clause 42, the first word that is written under the definition, that is the major thing, that foreign company is a company which is incorporated outside India and it has a place of business in India. If I am an Indian company and I have invested outside, and that foreign subsidiary, if it would have been incorporated outside India, you're my holding company and you have a place of business in India, then it would be a foreign company. All right. Yes, because it is clearly mentioned that it is an Indian company. So Priya, excellent. So if it is clearly written, so what you have to see is the definition is the most important part in case of foreign company. So I told you last time, foreign company is a company which is incorporated outside India and it has a place of business in India, whether itself or through an agent. So the first condition only if it is not met, Nanda Goel, if the first condition is not met, then it is never a foreign company. If you are incorporated in India, you can never be a foreign company. So you are a company which is incorporated outside India, you're a body corporate, and after that, if you have a place of business in India, it will be covered as foreign company. Okay? All right. And what is your question? Hardik has written a question related to audit chapter. I have a doubt in audit chapter. There is a case of non-government company. To the subsequent auditor to be appointed, procedure is not given in the casual vacancy, which arise is given in the ma'am subsequent auditor, then casual vacancy. So yes, absolutely correct. Then you're just passing the resolution by the shareholders, Hardik. So you simply have to see the sequence in case of a government companies. C and AG is given first number of days, and then if they are not done, then board of directors and then shareholders and AGM are appointing. But if the casual vacancy is occurring, the same procedure has to be followed as we have discussed. All right. The only case is when you're passing the resolution, yes, that will be the ordinary resolution that you have written. That is absolutely correct. Other than the casual vacancy case, that is absolutely correct. All right. Okay, Nanda Goel, we refer to that first example that you have written. I will just check it out from the study material and discuss it with you. All right. So let's move ahead in this chapter. Any other query related to the definition of section 2, clause 42? Because today we are going to do number of questions also. So let me take your test from the question answer rounds before we proceed ahead, because the most important part of this topic foreign companies, that is companies incorporated outside India, is the definition only. So if you're not clear about the definition, then the things will become little dicey for you. So here is the first question. Let us understand how we have to write the answers also. So Trans Asia Limited is registered as a public company under Section 4, Clause 7 of the Erstwhile Companies Act, which is a subsidiary of Galileo Limited, a foreign company. Now, here is a company which is registered as a subsidiary of a foreign company. And TransAsia carries on business in India, describing itself as a foreign company. State the actions that can be taken for the improper use or description. So, are they doing something which is improper? Can you use the name as foreign company or not? This is what they're asking. Now, this is a related question. Here, you are a company which is registered as a public company within the Companies Act. So, it is an Indian company which is having a subsidiary, but that subsidiary itself is a foreign company. All right. All right. So let us see how you have to present this answer. So now, foreign company, I just explained you will have to write down the definition. In this case, it is a company which is a company or a body corporate which is formed outside India and has a place of business either by itself through an agent, physically or electronically, and it is conducting any business activity. Even if it is not having any place of business, I explained you in the last class that this word has to be read as or. Any business activity, if you're doing in India and you were formed outside India, you will always be a foreign company. So in the instant, so first you will give in exam the provisions of the case. Then you will write the facts of the case. In the instant case, this is a registered public company, which is a subsidiary of Galileo, a foreign company. Now it says, though TransAsia is a subsidiary of foreign company, but since it is registered in India, it is not a foreign company. Why? Because you're incorporated in India. Just because you're a subsidiary of a foreign company, you don't become. You have to have a company which is incorporated outside India. So here, this TransAsia Limited company is not a foreign company. Why? Because it is registered in India. Hence, it cannot describe itself as a foreign company. So all those who have answered it is not a foreign company, absolutely correct. Why? Because it is incorporated within India. It is registered in India. All right. And it is not. Pallavija, you are writing it is registered, but therefore, yes, absolutely correct. You have also written the correct answer. So action has to be taken. Now, this action is something which we are going to discuss in today's class. But since we have taken up this question, so let me explain you over here. If any company, children, try to illegally use itself the name of foreign company, because why we are studying foreign company which is incorporated outside India, inside India, both are body corporate. I explained you in the last lecture also. So body corporate is a wider term. Only thing is when it becomes a foreign company, this chapter number 12 that is related to foreign company provision, section 380 to 393 becomes applicable to them. Okay, this is what we have done under section 379. So first of all, definition has to be very clear. So once you become foreign company, all those foreign company provisions will become applicable. But if you're not foreign company, then the provisions are not applicable to you. So if you're just trying to take certain exemptions or you're trying to misuse the name of foreign company that yes, I'm a foreign company, then investigation can happen against you. Okay, so this is written under Rule 12 of the Companies Registration Rules. If any person carries on the business under any name or title or describing themselves as a foreign company registered under this act, then those persons, unless the foreign company is there, unless it is duly registered, will be liable for investigation under section 210 of the act, and actions regarding this investigation will be taken against that person. So you cannot just being a subsidiary of any company which is within India and you had a company which is working there outside India, you call yourself as a foreign company. It is legally not allowed. And if you do, then investigation as per section 210 will happen. Now, section 210 is not part of your syllabus. You don't have to study in detail about investigation, but I will show you in the study material. Reference related to this point is given. That's why such kind of questions can come in the exam. So what we have to learn, we have already learned the definition, and if certain kind of questions come where they have asked you clearly that is there any improper use, what will you do? Then if there is any improper use and there is any description using as foreign company, then investigation under section 210 will be taken against such kind of person. All right. Is it clear? Okay. All right. So what is the meaning of electronic mode? Can you tell me, Fatafat, say in the chat box, because it is your revision going on, because then we'll be proceeding ahead. So we have discussed that the electronic mode, physical presence can be in India, and also they can be electronic mode. Anushka, Raj, Bhumika, yes, the session is going on in Zoom also. And if you're sending your queries here, we are checking it out here also. So not to worry. So to answer me quickly, what is the electronic mode? How can you say that it is electronic mode business in India? Either we are having a physical presence or it is an electronic mode. B2B transactions, B2C transactions, deposits, acceptance in India is happening. Very good. Financial settlements, cloud computing, market, medicine, absolutely correct. Data transmission, e-commerce, online services. Preeti Kumari, Tambeshwari, Nanda, Nayan, Hardik, all of you are correct. Manvi, Pallavi, very good. Rashmi, excellent answers given by all of you. That means you have revised your work well. That's great. Sukhveer Kaur, Kasak Yadav, very good. Ritika, Lahari Moruju has written all the points. Excellent, all of you. But if it is an IFSC unit, I told you there is an exemption which is given to the IFSC unit, International Financial Service Center, which are set up under SEZ units. Will they be applicable as a foreign company if you are a company which is incorporated in Singapore and you opened up a company in India in IFSC unit? Can you call yourself as a foreign company? No, because it is already considered to be outside India only. So you're not having any place of business. Very good. Excellent. All of you have given the correct answer. It will not be considered as the electronic mode. So it is not a foreign company. IFSC का लिखा होगा कुछ भी exam में. If anything is written, you will simply write it is not a foreign. Now, section 379, all of you remember what did we do in section 379? First, section 379 says that this chapter 380 through 386 are applicable, and also section number 319 to 393 will be applicable to foreign companies. Today, we are going to discuss all these sections, what these sections are trying to tell you. Each and every point will be explained, and you will find that it is a replicate of what we have done in the Companies Act 2013. Each and everything which is written in the earlier chapters will be becoming applicable under these headings. And 379 also tells you a very important thing, which says if 50% of the share capital, now you have opened up a company in USA and 50% of the shareholding is taken up by Mohan, who is an Indian citizen in India, or it is by ABC Private Limited, which is a company incorporated in India, means it's an Indian company. So if 50% of such shareholding is being taken up in India by an Indian body corporate or by Indian citizen, then what will be the implication? You have to answer me. What will happen if it is a company which is outside India, 50% of the share capital and 50% of the preference share capital, I'm saying. I'm not saying equity, I'm saying only preference share capital. Does it make any difference? No, ma'am. Either equity or preference, both are considered. So if they are being held by Indian citizens, then what will happen? Then all the provisions of Chapter 22 and other provisions as applicable to the Indian company will become applicable to this place of business that you have set up in India. So whatever India business that you're doing, although foreign company provisions are applicable to you, but the company, the business that you're carrying on in India will be considered as if it is a company incorporated in India. Okay, we'll be doing examination question also from this topic. Very good, Ajay, Surya, Supriya, Kasak, Tambeshwari, Ritika, all of you. Good answers. All right, so we have done section 380 also. So what happened? Tesla is still not has come in India. If Tesla comes to India, what will Tesla have to do? Within 30 days of having its first place of business in India, it will have to go to the ROC and it will have to file certain documents. So let's assume there is a company which is outside India and they have come up and set up their business place of the company which is set up in Japan, and they have set up their place of business in Pune. So they have to go to the ROC within how many days? Within 30 days. So they will go to which ROC? To this Pune ROC or Bombay ROC or Delhi ROC? All of you, before I ask the question, everyone has written this answer. Very nice. They have to file the documents with Delhi ROC. Dilip, Mahi, Ragini, all of you, good children. I have read it. I have read it. Anjali, very nice. So within 30 days of setting up the place of business in India, they will have to file the documents with Delhi ROC. Now, what are these 7 documents? This also you can tell me because we have done it in the previous class. Memorandum and Articles of Association, which is the charter of the company. In which language? In the language of the country or in any other language? In English language. A certified copy in English language. Very good, very good. Full address of registered office, full list of directors and secretary. We have done from the study material, their name, father's name, mother's name, spouse name, their PAN number, nationality, all those points which are written over there. Just give it a fair reading. Because children, this chapter is very, very small. So, but it is not too technical also, if you ask me. It's all about procedural things that you have to learn in it. So again, learning becomes easy when we communicate, teacher asks you, you answer it back. So learning it happens automatically. So these kind of chapters like companies incorporated outside India, LLP, FEMA, never try to leave a single thing out of these chapters because they are very small chapters. So you should do each and every point out of these chapters. And yes, learning has to be done. There is no escape route that you will say that I have understood, I will not learn. This chapter is actually all about learning only. So you have to learn it. All right, name and who is this 4th point related to? He is the authorized person who is going to receive the notices on behalf of the company. So if I have given the name and address of this person, say Mr. Kapil Sharma. So we have asked that Kapil Sharma is going to be my authorized representative. He is a person who is a resident in India. And I have given his name within 30 days to ROC that Mr. Kapil Sharma is going to act as my authorized representative. And I'm the company ABC foreign company, which is incorporated in Japan. Now, ROC wants to send any notice that you have not done this work properly or any filing is pending, they want to send it to Japan. Instead of sending that notice to ABC in Japan, they have sent it to Mr. Kapil Sharma. What will be it considered? It shall deem to be served to that person. That means it will be considered that it has been given to company in Japan. All the notices will be given to the authorized person. And is it mandatory that this person should be resident in India? Yes or no? Yes, it is mandatory. Okay, na? Essay, this like these kind of examples, just put it in your mind and it helps you to learn. Full address of principal place of business in India, any opening and closing of places earlier, directors, authorized representative, if they have been debarred from you have to give a declaration that all the directors and secretaries and authorized representative who are working with us, they are not debarred, they are not convicted for any kind of things. Any document which any foreign company is required to deliver will give it to Delhi ROC. And if any foreign company cease to have the place of business in India, it will again have to tell them it is their obligation. And any alteration also has to be given within 30 days. What is the meaning of alteration, children? What is the meaning of alteration? Alteration means changes. Yes, it has to be mandatorily, has to be in India. Ritika Gupta, very good. Rashmi is asking what related party transactions. It will come as section 381, child. Okay. Here you don't have to file those documents. That is related to section 381. Okay, Rashmi. Additional changes in the name of director, secretary, addresses. Very good, very good, very good. So all these alterations, Tambeshwari has already answered the question I'm going to ask. Hardik, you have answered it wrongly. You have written the wrong form. I'm going to ask it now. So which is the form which I will be using for filing the documents with ROC within 30 days of opening the place of business in India? Which form I have to use, children? Please tell me. I forgot. Absolutely correct. It is FC1 form. And if there is any alteration, like you told me, ma'am, changes in directors or change in the businesses or anything, then which form I have to use? Within 30 days of those changes, FC2 form has to be used. We have seen FC2 form within 30 days. We have seen these forms also in the last class and 40 answers in the chat books, which tells me that you have correctly understood. FC3, I'm coming to Lahari Moruju, I'm coming to FC3. Any alteration is FC2. Any changes which are happening is FC2. Okay, all those who have written Balesh, Nancy, Ingo, absolutely correct. Harshpreet Kaur. I think almost everyone who is with us on the Zoom, they have given the correct answer. So FC1 and FC2 is absolutely clear to all of you. Let me see the students on the portal also. Bhumika, Nishkaraj, Ankita, Manoj Kumar. Good. Ankit Mishra, absolutely correct. Yes, Manoj Kumar, your answers are absolutely correct that you have written. Good, good, good. Okay. So now, I hope section 380 is absolutely clear. No doubts in section 380. FC3, I was writing to change. Yes, yes, yes. Absolutely correct. Tambeshwari, Ajay Surya, all those who are writing FC3, that is for any change in business. I know I have told you last time and you have remembered and recalled it nicely. So that's great. So FC3 is specifically for any change in the place of business. All the above documents, the list of businesses by the foreign company is given in the form FC3. So FC3 relates to section number 381. But let me just complete one more point of section 380. We have not revised one more point. That is, if you're filing this application on FC1, along with FC1, you also have to give one declaration from RBI under FEMA and also from any other regulatories. And if foreign company ceases to have a place of business, then also they have to inform it that now this place of business is not there. This place of business changes is related to your FC3 form. So FC3 basically includes all the accounts of the companies, basically where you're giving all this information related to your balance sheet, profit and loss account. First of all, they will be prepared as per Schedule 3 only, as you have learned in accounts of companies. All these documents have to be given to the registrar. Central government may exempt certain class of companies depending upon the exemption that they can give. If any of these documents is not in the English language, a certified copy. So like you were giving a certified copy of MOA, AOA over there, here also you have to give a certified copy in English of balance sheet and profit and loss account. Along with the above documents, a list of any business changes that has been done by foreign company in India as on the balance sheet date has to be given in form FC3. Okay, so absolutely correct. Tambeshwari, Lahari, Moruju, Hardik, all those who were giving the reference of FC3 for the changes in the place of business in India is absolutely correct. That is FC3. But any alteration happening in the document submission will be FC2. This is your related to accounts of companies where you're filing all these documents. And along with this FC3, you will also be giving the financial statements you're giving. You'll be giving accounts of the companies, and RPT, related party transactions, statement of repatriation of profits, and transfer of funds, including dividend. So I told you repatriation means whatever profits you have earned in India, in Pune you have earned, now you're taking them to Japan. That is repatriation of profits. But if you're not taking it, you're transferring it as distributing it as dividend, then what is the amount that you have distributed as dividend? Transfer funds will also be given to the ROC. Is that clear? Within how many days this information has to be given? Like we have given this section 380 wala to jo hame kara 30 days mein. Even the alteration in 30 days events. Section 381, accounts of the companies has to be given to the ROC within how many days? Within 6 months. So if my financial year is ending on 31st March, then by what date I have to give? He will not be asking you 6 months. He will be giving you the dates. So the financial year is closing on 31st March 2023. So by how much? April, May, June, July, August, September, 30th September 2023, ma'am, we have to file it. If due to any reasons you're not able to file it, you will get extension till what date? Who has written 31st September? It's 30th September. 31st December, 3 months extension you can. Yes, absolutely correct. So ROC can extend this date up till 3 months. I hope you are remembering and recalling what we have done and you're not just cheating from the book and answering me. But I still remember that I've told you that even if you cheat an answer, it will help you in revising. So that's good. But I'm expecting that you're answering me honestly and not referring much to the study material. Okay? Okay. So 6 months is absolutely correct. And the extension can be given up to maximum of 3 months. Very good, very good. Lahari Maruju say, yes, ma'am, we remember everything you said. Very good. Before referring to study, and yes, absolutely correct. If Hardik has written, not at all referring. Wow, great. That's wonderful. So before referring means, yes, if you do not recall, then I told you, yes, you should refer it and answer it because answering helps you to retain the information over here. Good. All right. So chapter 10, audit and auditors. We said that now we're not going to write it over here because we have written balance sheet P&L. We are given 6 months, 3 months. We're not saying anything related to audit and auditors. You have studied the chapter number 9 and 10 with ma'am. So just replicate and paste it over here in the foreign company also. So smartly the law has been framed. They said that only section 380 to 386 and 390 to 93 is applicable. Actually, so many other sections of Companies Act are also applicable. Why do you think they're applicable? Because you're doing business in India. You're coming to India. How can you save yourself from getting audit done? What is the role of chartered accountants? They have to go and check your books of accounts, examine your books. Everything has to be seen, the true and fair view of profit and loss and balance sheet. So again, when you're doing business in India, you have a principal place of business in India. You're doing business out of foreign investments. You have invested money in India. So audit and auditors will be applicable as it is to you. What is the meaning of mutatis mutandis? Means as it is, this chapter is applicable to you. You don't even have to think what you have to apply. So examiner can give you a question like, it is a company incorporated in Singapore and it has opened a place of business in Delhi. And this is the place of business, ABC Limited, which is doing business in India. Do you think they need to apply a section 138 appointment of auditors, 139 appointment of auditors is applicable to them? What do you think? Do they have to follow the procedures? What is the procedure for appointment of auditors? So as it is section 139, you have to write. Okay, give them the thing also. If it is a government company, what is the procedure? If it is a normal company, what is the procedure? 30 days, 90 days, yes, by directors, first auditor. Very good, very good, very good. I know you remember that. That's great. And what was the additional point after the accounts of companies? Is there any annual return that the foreign company has to file? Within how many days the annual return needs to be filed? Within 60 days from the date of the financial year, end of the financial year. So 6 months period, extension 3 months, and 60 days, that is by 31st March, April, May, 31st May, you have to file this annual return also in form number FC4. All the forms we have done. Form number FC4 clearly talks about filing of the annual return. Yes, it's exactly the same like you have done in MGT chapter, that is MGT 7 form. Same, Hardik, it's absolutely correct. Good. But here you have to file it in FC4. Now let's move to section number 382. Again, a beautiful descriptive picture in front of you so that you can remember. So what is the meaning of displaying of your name? So Shah Rukh Khan stays in a very big house and outside the name it is written Mannat. Mannat or Jannat? What is the name of Shah Rukh Khan's house? I think Mannat is written over there. What is it? Jannat or Mannat? What is it? Tell me please, I can't recall. It's Mannat only. Okay. Oh, see. Oh, so many of you have written it. You remember the name of Shah Rukh Khan's house building also, huh? Okay, Kiran, I will explain you that repatriation. So like it is written outside the name, similarly, when you have opened up a foreign company and the principal place of business in India, you need to display the name outside. So section 382 is simply telling you that the way he has written his name outside his house, you also have to write the name of your company, then display the name of foreign company on all the documents, on all these letterheads that you're going to use in all the company's bill paper, notices, and other publications. The name of foreign company and the country in which it is incorporated shall be written on all the offices where it carries on the business in the letterheads also and outside the place of business also. So you have opened up the business in Pune. So whichever building you're having outside, you have to write the name of foreign company. So first of all, exhibit the name outside every office. Number one, outside every office. Let me use a different darker pen. So outside every office, it has to use. Second is on all the letters. Third is legible in English characters. What is the meaning of being legible? Legible means you should be able to read it. Legible means you should be able to, it should be visible clearly. Like my one, I have written one. It is not clear, right? It is not legible. So when I write like this and I circle it, then it appears clear. But when I write like this, it's not very clear. It's not legible. So it should be legible. It should be understandable. It should be clear. Languages in the general use in the locality in which the principal places, and one in the language of the general, that means vernacular language. So one, it should be in the English characters also, and another in the language in which that state in which the principal place is situated. So name of the foreign, what has to be displaced? Number one, name of the foreign company and the country in which it is incorporated. It belongs to Japan, so you have to tell them it is the country of Japan. And all the business letterheads, name of the company and the country in which it is incorporated, it is to be stated in legible English characters and cause the notice of that fact when the liability of the members of the company is limited. You also have to tell whether the liability of the members is limited or it is unlimited. So what have you decided? You have designed a company which is a limited company or it is an unlimited company. So you have to tell about that also in detail. So number one, foreign company's name, country in which it is incorporated, on all the business letters, bills, heads, and all the notices, you have to use this name. And third thing you have to tell is whether the liability of the company is limited or unlimited. Is that clear? Now, section 383 is again very, very simple. And again, it is very important. It is related to somewhat what you have studied in section 3. It says any notice, processes, or documents which are required to be served to the government company will be sufficiently served. Means मान लिया जाएगा कि serve हो गया है. Yes, outside every office, name of company in vernacular language also. Very good. Kasak Yadav, that is absolutely clear that you have written. Your understanding is clear. All the notices, documents which are to be served to foreign company will be sufficiently served. Number 3, if it is addressed to the person whose name and address has been delivered to the registrar. Who was that person? Do you remember? I just named that person Mr. Not Mohan, he was somebody else. Kapil Sharma. Today we have taken Mr. Kapil Sharma, who is Indian resident, whose name has been given under section 380. If the notice is given to him, it will be considered as the notice is served to the foreign company. And section 383, children, simply tells you how this notice has to be served. Notice usko dena kaise hai? Left or sent by post at the address which is delivered to the registrar or by electronic mode. What is the electronic mode? Email? WhatsApp? What are you going to use? So email is the official kind of thing that has to be used. So either you go and leave it outside his house in Pune, or you send it by post address on the address which has been given to the ROC, or you email it. It will be considered as if this document has been served to the company. He is the authorized person. Absolutely correct. Correct. All of you have written the correct points. Let me see the students on the portal also. I hope they're understanding everything. Yes, Manoj Kumar, Ankit Mishra, all of you. Bhumika, Anushka Raj. I hope it's clear to all of you. Very good. All right. Cloud computing. Manvi, cloud computing is the electronic mode that you're using for showing your presence in India. Here you are sending it the notices, okay? Here you're using the email. Email is the electronic mode that has to be used, okay? You are sending the notice. Basically, it is talking about sending the notice. With there, it is talking about doing the business. So what are the 4 points for service of documents means? Document serve करना. Documents हमने पहुंचा दिए, उसको दे दिए, either by post or by giving it by hand or by email. Is that clear? Okay. Now, section 384 is very, very interesting section because I feel like taking your test of the chapter of Companies Act when I talk about section 384. Do you think, can you feel anything by seeing the slide? Can you remember anything? What is section 384 talking about? Section 384 is telling you, my dear students, Section 71 related to issue of debentures applied to foreign company. Section 92, which you have studied relating to annual return, and Section 135 of CSR applied to foreign companies. Section 128, books of accounts applied to foreign companies. What was Chapter 6? Registration of charges will also be applicable to foreign companies. And section previous chapters, yes, mutatis, very good, very good. Provisions of chapter number 14, which is not part of your CA inter syllabus, inspection, inquiry, investigation, will also be applicable to the Indian businesses. As it is applicable to Indian companies, it will also apply to the foreign companies. What was debentures? Do you remember chapter number? Can you just name me the chapter number under which you have done section 71? Very good. Share capital and debentures, chapter number 4. Very good. So whatever you have studied over there in debentures, who was a debenture trustee, debenture holders, whole of the chapter is applicable to foreign company also. So be very careful. Examiner can give you the question related to debenture out of the foreign company. So he can try to cover both of the chapters. Filing of return, section 92. What have you studied in section 92? Yes, Kasak Yadav, you have to write chapter 6 and chapter 14 because this is the provision that is under section 384. 384 says like this, that these sections and chapters are provisions of the chapters are applicable. So where I'm saying provisions of chapter 6, Pacha, it means whole of the chapter of registration charges is applicable to you. But where I'm specifically talking about section 71, section 99, 92, that specific section is applicable to foreign companies. Okay. Okay. Accounts of companies, chapter 9. So section 128 only they have adopted from that. But other chapter, they have made it applicable in accounts of companies also. What was section 128? Can anyone tell me? What do you recall from section 128? Filing of annual return. That's great. CS in practice will audit the annual return. MGT 7 and 7A. Oh my God, this child is going to get beyond exemption. Hardik, excellent answers given by you. Books of accounts. Okay, I know it's books of accounts. It is written over there, Nanda Goel, section 128. I'm asking you, what do you remember out of section 128? Let me just check do some memory testing of your, how much you have memorized. Maintenance of books of accounts. Okay, Lahari Morju, how you have to maintain the books of accounts? What have we done in section 128? To be kept at, okay, RO and director can only inspect it, not even the representative. Periodical returns, you remember, very good. Liability 50,000 to 5 lakh. Do we have any imprisonment if books of accounts are not maintained properly? Yes, the definitions, books and papers, very good, Preeti Kumari, all of you. Oh my God, somebody has written the full-fledged answer. Supriya Kadam, great. Yes, Hardik, 129 financial statements has imprisonment, not the others. Preeti Kumari, good. Dilip, very nice. Good children, no imprisonment, good. Ajay Surya, Pallavi, 8 years provision, that is great. So you remember. Good. Okay, anything regarding registration of charges that you remember that you want to share? Write it in the chat box. Let's have a recall of chapter number 6, what you have done. Charges, CH1, 2, 3 form. Remember? All those provisions of register. What is the meaning of charge? Any loan being given, any borrowing being taken, any security has been provided. So charge has been created. It has to be properly secured. And that charge that you have created has to be registered with the ROC. Okay, good. And chapter number 14, so we have not done. It is not part of the syllabus. So we simply have to remember if examiner asks you what are the provisions of section 384 when you ask about what all provisions of Indian companies are applicable. So you have to remember these 5 sections, section 71, 92, 128. What is 135? What is 135? Do we have any corporate social responsibility? Why do you think CSR has been made applicable to them? See, again, they have taken it from chapter number 9, accounts of companies. Why not written chapter number 9? Because kuch sections are times. All right. So 135 is very important. You are coming and using our Indian resources. You are taking out benefits out of that Don't you think that we have to ask them also to do certain responsibility towards the society? So again, they also have to do the corporate social responsibility. All right. And then 128, chapter 6 and chapter 14 relates to investigation and inquiry. It is also applicable to the foreign companies. 385 is nothing. It simply tells you that whenever you're going to the registrar, you need to pay certain fees for registering any documents required by the provisions of this chapter to be registered, such fees as may be prescribed. So if examiner asks you that what is the, somebody has asked me a question in between which I left while answering, while taking your questions. Where is your question? You can ask me again. किसने पूछा था? Rashmi was asking or Ritika, somebody was asking. हाँ, Kiran Mishra of repatriation of profit. Repatriation of profit means that I am a company which is formed in US and I have opened up a place of business in Mumbai. Now at the year end, I am filing my annual accounts. So whatever is my profit, FEMA is another act that you will be doing, Foreign Exchange and Management Regulations. You have to take certain approvals from RBI, and FEMA Act is applicable whenever you're taking any money from within this country, within India to outside India. Now, you are US citizens, you are doing a place of business in India, you are a foreign company, that's why this Companies Act 2013 is applicable to you. So it says whatever profits that you have earned in India, if you're taking those profits to your country, US, you're allowed, first of all. You have to give them a statement of this repatriation of profits done. Means जो भी आपने इंडिया में कमाया है वो बाहर लेकर जा रहे हो तो उसकी एक स्टेटमेंट दे देना कितना प्रॉफिट आप बाहर लेकर गए. You simply have to give a statement how much profit that you have earned in India you are taking to outside to your country. That statement is known as repatriation of profits. And transfer of funds means you're not taking it outside India, you're distributing it to the shareholders or you're giving it away as a dividend only. That statement also needs to be given. Okay, Kiran Mishra, I hope this point is clear to you. Now, this section 385 relates to fees to be paid. Whenever you're going to ROC, you have to pay certain fees. So what we have to remember in this section, ma'am, as may be prescribed. So yeah, they have not told you any fees to be learned, but MCQ can come at very rare chances because it's very simple section, nothing it's saying. So any fees, do you have to pay any fees for registering of documents? Yes, we need to pay the fees. What is the fees? Whatever is prescribed by the ROC, that fees needs to be paid. That's it. Finish. Section 386 talks about interpretation. Now, section 386 tells you what is the meaning of interpretation. Certified. What is the meaning of the word certified? Certified means if I ask you that you have to give me a certified copy of your Aadhaar card, what will you get it done? How do you get your copy of Aadhaar certified? You get it approved or authorized by someone, you will do a self-attestation. That is what we do. He'll sign it. Okay, very good. That's great. So true and fair copy has to be given. So certified, yes, that logo, very good. Photocopy, authorized, original Aadhaar card will be shown. Very good, Tamishwari, Rashmi, Pallavi, all of you, Supriya, Nanda Goel, great. So here certified means, so it says, what is the interpretation? What is the meaning of these few words that you have been using? When you said that, ma'am, we are filing MOA and AOA of the company with ROC and it has to be, the English copy has to be a certified translated copy. So that means you have to give a true copy or a correct translation. So maybe, and when the translation is done in India, then a person of any particular designation, like it has to be signed or authenticated by an advocate of a high court, or by a person who, in the opinion of ROC, is having the awareness and the awareness of both the languages. Say, for example, it is written in French. So the person who is expert in French, that person can only certify it. Then only it will mean a correct translation. A ROC is not going to see and read all the documents, whether the correctly has been done, or it will not apply a dictionary to see if the translation is done correctly or not. He will say, give me a certified copy, means it has to be certified by the person who is aware about this language and see that the correct translation has been done. What is the meaning of director in relation to foreign company? Includes any person according to whose instructions or directions the board of director is accustomed to act. So here the director means any person according to whose instructions everybody is acting in the business. Place of business includes a share transfer and registration office. Very important. I told you in first day only that if you have opened up, if you are a company in USA and you have opened up a share registration office in India, do you become a foreign company, yes or no? You're a company incorporated in USA and you don't have any business in India, but you have opened up a share registration office in India. Yes, ma'am, because share registration and share transfer means place of business in India. So yes, we become a foreign company. Kiran has written no. Why have you written no? Yes is the correct answer. Neeru is also writing no. So Neeru and Kiran, it basically means that even if you're a company incorporated outside India, not doing business in India, but if you have place of business includes this terminology. I explained you earlier that share transfers now are being done online only. जैसे अपना शेयर हमने किसी को ट्रांसफर करना है तो ऑनलाइन प्रोसीजर फॉर ट्रांसफर एंड ट्रांसमिशन ऑफ शेयर्स हैपन अर्लियर दे यूज्ड टू बी फिजिकल कॉपी दैट यू हैव टू टेक एंड यू हैव टू ट्रांसफर योर शेयर्स so when you use this physical copy you have opened up a place of business which is only a share transfer place. So any share transfer or share registration will be considered as having a place of business in India and then yes you become a foreign company. Okay, yes Sukhbir, Ritika, all of you are correct. All right. Now, a very interesting section, section number 387, which tells you that what you have to do about the prospectus. First of all, now since we are moving ahead to a very interesting topic, that is prospectus, all of you have to tell me what is a prospectus. So now we are moving back to chapter number 3. Chapter 3 की provisions भी इसको applicable है, but like it has made chapter 9 and 10 chapter mutatis mutandis, 71 mutatis mutandis, it has given certain regulations under 387 and 388. Means after section 379, 380, 381 that you have learned, the learning part again starts from section 387. The rest were in between, which is for a reading understanding. It's very simple. So here now prospectus starts. What is the definition of prospectus? Shelf prospectus, abridged, yes, all these prospectus are part of prospectus. But what is a prospectus? Why do you need to issue prospectus? Inviting shares from the public, inviting subscriptions. Very good. Rules and regulations are given in prospectus. Yes, that's correct. But I'm asking you, what is prospectus? A document which is issued to invite the public for coming up and taking up shares, subscribing to a securities. Very good. Excellent. Invitation to the shares. All of you have written the correct answer. So now here, why is the need of, yes, Apurv? It's absolutely correct. Nahari, Moraju, Pallavi, Nanda, Gopal. Correct. Here, what is the need of issuing a prospectus? So now you are a foreign company incorporated in US. You have opened up a place of business in India and now you want public to subscribe to your shares. You're becoming a public company. You're listing your securities also. So you have to, my dear, issue a prospectus because chapter 3 will come applicable to you, under which section 26 that you have learned relating to what the contents of prospectus. Section 34 and 35. What was section 34 and 35? Civil and criminal liabilities. If you're doing any kind of errors, 447, all these things will become applicable. If you try to raise any kind of securities in India, you have to issue a prospectus if you're offering securities for a company incorporated or to be incorporated outside India, whether the company has established or will establish a place of business, unless, so no person will issue means, so what are the procedures required for the prospectus? This is what they're going to tell you. Okay. Yes, it's an initial document for funding, Ritika Gupta, that's correct. So following matters have to be contained in the prospectus. Number one, it shall be dated and signed. Very, very important provision. Prospectus is always and always dated and signed. Dating of prospectus and the particulars to be contained are given under section 387. So the first topic point is it should always be having a date and it shall always be a signed prospectus. Then only you will consider it as a valid prospectus. Otherwise, it is an invalid prospectus. If it is not dated and signed, it is an invalid prospectus. Second, it will write about the constitution of the company's MOA, AOA instrument containing the definition, defining the constitution of the company. What is the meaning of constitution of the company? How the company is formed? What is the business of the company? What is the purpose of the company? Object clause, name clause. All the details are written in the MOA and AOA. The enactments or provisions under which the incorporation of the company has taken place. Now, what is the meaning of the second point? First is that it has to be dated and signed. Then these are the particulars that matters which has to be included in the prospectus. Number one, you give them the detail of MOA and AOA. Number two, you tell them the enactment under which you have been formed. So you're a US company, you will be having certain US laws applicable to you. In the company, in the country in which you are formed, what is your enactment? We follow Companies Act 2013. What do you follow? You must be having certain provisions of your law of your country. So you have to tell them their provisions of that country. Address in India where the enactments and copies, if they're not in English language, a certified translation in English language has to be given. So what is your address in India, and whatever enactments and copies and provisions, if the same are not in English language, then certified copy, again, certified word will be doing the interpretation in detail that who will have to certify. The date on which the company was and the country in which the company is formed. So what is the date when it is formed and the country in which the company is formed? Whether this company has established a place of business. If yes, what is the address of the Indian office? State that the matters given under section 26, that is matters to be stated in the prospectus, which SEBI tells, whatever the SEBI tells, whatever the details are given over there. Remember, section 26, declarations, SEBI regulations, all these procedures have been followed. All the matters of section 26 have to be included. Again, there is a small exemption. So first of all, you have to remember section 387. How do we have to learn it? Section 387 talks about whenever a prospectus is being issued for offering the securities, it has to be dated and signed. Then we have to learn 5 things to be included in the prospectus. Number one, your MOA and AOA. Number two, whatever the country rules and regulations in which it has been formed, enactment, what are those provisions? Date and the country in which it is incorporated, address in India, and a certified translation in English copy if it is not in the English language. And if it has established the principal place of business in India, then you have to give that address in India also. Very important line. Provisions of point 1, 2, and 3 will not be applicable to the company if it has been more than 2 years from the date on which the company has commenced the business. So it says that if there was a company which started up in 2023 and in 2025, it is coming out with a prospectus. So you have already got yourself registered with ROC and you have filed the documents in 2023, and in 2025, you're coming with the prospectus. So it has been more than 2 years now. Say, for example, here you got yourself registered in July 2023. And here in December 2025, you have decided to come out with the prospectus. Then 3 points that is related to the constitution of the company, enactment and provisions, and address in India about the certified English language, they will not be applicable. Other points will be applicable. Other matters will be included. Then these first 3 points will not be included. All right. So let's take a small break here. I'm going to ask you questions from section 387. Just go through all these section 380 to 387 from the study material. We'll take a small break. And after 10 minutes break, I'm going to ask you questions from that. Okay, let's take a break. So I hope you have gone through the provisions related to prospectus. So quickly answer me, if 2 years have passed or to a foreign company which has been incorporated in India, what all information will be required to be given for the prospectus? What all information will be required to be given if the company is issuing a prospectus and 2 years have passed? Place of establishment, date of incorporation and place, and the country of incorporated, date, address. And also you will write, very good children, and you will also write that all the provisions specified in section 26, whatever the SEBI regulations and everything is given, that should also be included in the prospectus. Nanda Goyal is asking, ma'am, what is the meaning of no person shall issue? When we say no person shall issue, unless means unless it is dated and signed, it will not be issued. Means if you have not signed it, if you have not dated it, you cannot issue the prospectus. So it is a negative sentence that makes it mandatory to date and sign the prospectus. Then only you can issue. If you have not put a date on it, if you have not put any kind of signatures on it, then you cannot issue it. Yes, under section 384, but the chapter number 14 in itself is not applicable to you in your syllabus. But yes, you have to learn it as it is, that it is applicable to foreign companies. Okay, correct answers given by all of you. Company should give information about their business model also. Karan Kumar, absolutely correct. So the only thing is that you simply have to write that the first 3 points, you will not write that the examiner can ask you what are the 3 points that are not mandatory. So if I ask you now, what are the 3 points that you don't need to give in the prospectus if you have been more than 2 years that you have been formed? Then what will you give the answer? I mean, I'm just opening it from here. So this section 382, we have done all these things that you have to state in the prospectus, and the advertisements, locality, service of documents is also clear. This point of 384 we have cleared. So just refer to my notes. You simply have to see my notes. You don't have to read this much in detail. FC4 we have covered with the accounts of the companies. Yes, MOA enactment provision, address in English. Very good, very good. Okay, Nanda Goyal, example number 1, she wants me to take up. I'll just take that example. Airlines who operate their booking agents will be covered under the definition of foreign company. So again, see, they have given you the examples related to these points that if you're having any kind of agency, if you're trying to establish any place of business, then yes, you will be considered as the foreign company. And here you are rendering satellite services. That's the reason it has become covered under the definition of foreign company. Actually, they should have given this electronic mode definition first, and then they should have given that example. So that's why the doubt comes over there, because the satellite services and all the data communication, data transmission services, they are mentioned over here. So that is basic reason why they are making that chain of foreign company, because although it is a subsidiary, but the data transmission and other kind of services that you're providing, it is being provided services from that foreign company within India. So that is the main thing that you have to see. And another thing is, we will be doing many important question answers today. So you will get a clear-cut picture of the definition, how you have to attempt the question in the exam. Okay. The only thing you have to remember is, if it is a company which is formed in India, incorporated in India, then it can never be a foreign company. Now, moving on to this point, I think we have done example number 3. First, let me just complete the points with you, and then I'm going to take all these question answers with you. So any doubt in 381, 382, till 387, I think we have completed. So let me go to 385 if we have missed out an example. Yes. Let's do these illustrations, which are very, very important. Illustration number 2, examine with reference to the Companies Act whether the following companies can be treated as foreign companies. So it is a company incorporated outside India. It is having a share registration office in Mumbai. Will it be considered as a foreign company? Yes or no? Answer me the illustration 2. First point you have to answer me, children. Let me see the students there with us on the portal also. Absolutely correct answers given by all of you, because the share registration and share transfer service is included in the definition of place of business. Yes, absolutely correct. Balesh, Harshpreet, Nanda Goel, Hardik, Bhumika, everybody. Bhumika has given no. Bhumika, it is not correct answer. Supriya is also saying, Acha, you are saying no for the second one. I'm asking for the first one. Indian citizens incorporated a company in Singapore. The second one, is it a foreign company? Yes or no? Absolutely correct. It is not a foreign company. For the purpose of chapter 22 of the company's place of business includes the share transfer and registration office. That is absolutely clear to all of you. Everybody has answered it correctly. Place of business may be in your own name or through agent. This is section number 386, interpretation. I wanted to show you the certification point over here. A company incorporated outside India having the share registration service in Mumbai will be treated as a foreign company. Company which is formed in Singapore for the purpose of carrying business in Singapore will not fall here. Why? Because it is incorporated outside India and it is not doing anything in India, then you're not supposed to have a foreign company in India. So the first point, 387 subsection 1 says that the prospectus should be dated and signed. You don't need to even read this. You simply have to remember the prospectus should be dated and signed. This is the legal language that they have written. And when you're issuing the securities, you will not be allowed to issue the prospectus if it is not dated and signed. And these are the 5 things which we have done test also. Now let's move to example number 7. Mir Company LLC, a company incorporated in Dubai, 28th April 2019. It was established a place of business in Bombay. So first thing that you have to see in this question is, what is the first thing? Share registration service, Karan Kumar is asking. So any office that you have opened for registering the share certifications are to be issued, or the transfer of shares is happening, the same meaning that you have done in a share capital and debentures where you have studied about the transfer and transmission of shares. It exactly means the same. Okay, Karan? So when you are registering the shares means the procedure that you have to follow, allotment of the shares is happening, all those kind of things. Earlier, you used to have certain offices related to these kind of things. Okay. So incorporated outside India and it is having the place of business. So immediately it comes to your mind that it is yes, a foreign company. Now this place of business proposes to offer securities. The place of business in India before going for subscription will have to file the prospectus. And the prospectus shall not be required to contain these 3 points. Why do you think they're not containing these 3 points? Because it is issuing the prospectus in the year 2022. They have established the place of business. It's been more than 2 years that they have set up their business. So if you had your place of business, so it says it shall not be required as the prospectus will be getting issued after more than 2 years since it has commenced its business. So once you have commenced it, more than 2 years have passed after the date the company has commenced its business, then you're not required to give those 3 points. Okay. Yes, Lahari Morujo, absolutely correct. And Pallavi has also written nicely that FC1 will also be filed. Absolutely correct. No waiver in compliance of prospectus. Now, this is very important. 387 subsection 2 tells you that whatever happens, if you're issuing a prospectus and you're a foreign company, you will not be waiving of any condition. Any condition requiring for the securities to waive compliance with the requirement or to impute any notice not specifically referred shall be void. It says you cannot say that we are a foreign company and we are waived off from the compliance of prospectus. No. Section 26, 20, 34, 35 will be applicable to you if you are issuing any kind of securities in India. You will have to issue prospectus. You have no waiver of compliance. Means you cannot apply for any exemptions and you cannot say that I'm a foreign company and this compliance is not applicable to me. There is no waiver for this. You have to have your compliance with the prospectus has to be done. And if any provision says that you are not required, that will be void. It is understood that 387(2) does not provide any exception for the non-compliance of the prospectus. Any person responsible for issuing or circulating the prospectus has to comply with 387 subsection 1. Form of application form to be issued along with securities. Now, you remember whenever we have discussed about these prospectus, we have also, yes, 23 to 41 will also be applicable. Absolutely correct, Hardik, but they are simply not applying the chapter number 3. You're giving provisions of this specific sections. Yes, Supriya, you need to follow all these conditions. Very good, correct. Now, application form, you remember, whenever the prospectus was issued, we used to give the application form also. Whenever the issue securities are being issued, they will have the understanding for applying the securities. They need to have the application form. Similarly, 387(3) is also saying the same things, that a form of securities to be issued mentioned unless the form is issued with the application form. So the heading only you will learn, that is sufficient, that the application form also has to be given along with the prospectus, which comply with the provisions of chapter 22 and does not issue any contravention of section 388. Section 388, very important section is coming up, children. Okay. I was just looking for that certified thing. I have not explained you. So just remind me later on, I'll make you write down how the certification has to be done. So if you're having any true and correct copy of any photocopy or translated copy, I was telling you that you have to be given the interpretation meaning of section certified. Just remind me, I'll make you write it down. Okay. So 388 provisions are very important. It is shown that application form in connection with bona fide invitation to a person to enter into underwriting agreement. So the only exception is when you're using for the underwriting agreement, then application form is not compulsory. So please write down a note over here. You can simply write down in your own words that application form is to be used along with prospectus. Application form is to be issued along with prospectus. The only exception is if it is underwriting agreement. If it is underwriting agreement, then application form is not mandatory. Then application form is not mandatory. Okay. 388, I have not done with you. I will explain you 388. First, let's do section 387, subsection 4 says, again, provisions of 387 are not applicable. So when is the prospectus NA not applicable? Over and above, we have written a point where the application form is not applicable in case of the underwriting. When is the prospectus not required to be issued? Remember section 26? Rights issue, uniform shares, existing shareholders, same. If you are, it will not apply if you are issuing to the existing members or debenture holders a prospectus or application form where the applicant will not have the right to re-announce in favor of. So where this is talking about the issue of shares to the existing shareholders, you're doing the rights issue. When you're doing the rights issue to the existing shareholders, prospectus is not required, except as it requires a prospectus to be dated to the prospectus which are not in respect of uniform with the securities. So if you're issuing the securities which are uniform with the previously issued A-listed securities you're issuing, again you're issuing the same securities, prospectus is not required to be issued. There we were doing section 26 is not applicable. Here it is a foreign company, so it is saying section 387 is not applicable. Is that clear? Easy? Now you can see this chapter is so easy. But this chapter is easy and to remember only if you have done your homework very well. That means chapter 1 to chapter 10, if you have done very well, then this chapter seems very easy. But if child has not done prospectus chapter only with not very nicely, then he will definitely going to get very confused over here, because he will not understand the meaning of, will not have the right to re-announce, previously issued, uniform. He will not understand. But the child who has done chapter number 3 prospectus very nicely, we did this long back in September. Remember, 4 classes we had for each and everything in detail. We have discussed about prospectus. If you have not seen that, you can refer to that recorded lecture. You can revise your concepts, because it is very, very important chapter. So if you remember that, then Foreign Company Section 387 will be just on your tips. You don't simply have to read it. 387 shall apply to prospectus whether issued in formal formation of company. Okay? So simple. So this is not applicable. And what is not applicable in case of underwriting agreement? Application form is not. Again, 387 will not apply for the prospectus differing uniform with respect to. So same point it is writing again. So it's okay. You can leave this. Section 387 shall limit or diminish any liability which may be incurred for the time being in force, apart from section 387. Nothing in section 387 will diminish or limit your liability. So again, I told you that we are not going to exempt you for any non-compliance. Any non-compliance is void. And similarly, it tells you that we're not going to diminish, means we're not going to reduce any kind of liability under section 387. Now, when the prospectus was required to be issued, there is a company, ABC Limited of USA. It has a principal place of business in Pune. It wanted to raise money from India. Then we are issuing the prospectus. When was Section 387 applicable? Any company outside India wants to raise money from India. They're issuing the securities to Indian citizens. Then the requirement of prospectus, entire Section 387 that you have learned with me, has to be written if such kind of questions come. Now, what is section 388? Prospectus will comply with the provisions of chapter 12 and 388 has to be followed. What is 388? Experts, consent and allotment. Do you remember anything related to expert? If you have taken any consent from the expert, then expert's consent has to be attached in the prospectus. That consent should not have been withdrawn, and a declaration that the expert has given his consent and he has not withdrawn his consent also has to be attached. So remember these 3 points that we have done in chapter number 26, chapter 3, section 26. Same things we're going to do over here. Section 388 tells you that no person shall issue, means whenever you're issuing or distributing the prospectus incorporated, the company will make sure that the place of business, the prospectus will include the expert. Any prospectus which is being issued, so point number 1, it tells you that where any expert's consent is required, it shall be given by an expert. He has given it before the delivery of prospectus. So first point is expert's consent shall be taken in writing and he has not withdrawn this consent. Point number 2, application made for rendering the services. Provisions of section 33 and section 40 are also applicable now. What is section 33? Legal language line by line. Okay, Nanda Goel, we'll do that. Don't worry. Valuer, engineer, CA, very good. I'm so proud of you, Pallavi. You remember the definition of expert. That's great. Not withdrawn, given the consent. Very good, Hardik. So section 33, abridged prospectus, all those securities issuing application form, and section 4 also. It is also being made applicable. Expert's point is clear now. Expert consent will be taken, number 1. He has not withdrawn this consent. His statement will be included, which is to be included, and he has not withdrawn his consent. Whatever I just spoke, just write down in the points so that you don't forget. Okay, Nanda Goel has a doubt in this point. No person shall issue, circulate, distribute in India any prospectus. What is the meaning of this line? When do you issue, circulate, or distribute prospectus in India? If there is a foreign company, ABC Limited, which is set up in USA, and it has a principal place of business in Mumbai. Can I say it is a foreign company? Yes, ma'am. No, ma'am. Yes, ma'am. It started business 2 years more. Leave those three contents. You simply have to give fourth and fifth and section 26. Clear, ma'am. Now it is planning to invite securities from Indian citizens. It is going to get listed on the stock exchange following provisions of section 40 and section 23. And while inviting the securities, it is going to issue the prospectus. So it says no person will issue the prospectus offering the subscription for securities incorporated or to be incorporated outside India. Means you're a company outside India, in USA, you will not issue the prospectus in India. Whether the company has or has not been established, or when it will be formed or will not establish a place of business in India. What is the meaning of this line? It is just simply trying to define the foreign company, that it is a company incorporated outside India and it has a place of business in India. You will not issue a prospectus. If the prospectus includes a statement to be made by the expert he has not given, or before the delivery he has withdrawn his written consent to which it is to be included, or it does not appear in the prospectus a statement that he has given and he has not withdrawn. Now this is a negative statement. I always tell you, वो कह रहे भी अगर ऐसा नहीं है तो आप मत करना. If it is withdrawn, he has not given it, then you will not issue the prospectus. So let's read it in a positive way. You have understood the law, how you have to learn and remember it. You will issue the prospectus only if you have taken the written consent from the expert, he has not withdrawn that consent, and the statement shall be included in the prospectus that this consent has been taken and he has not withdrawn his consent. I hope everybody is clear on what I've explained you. Or if you want, I will write it down for you so that you can write in your notes also. Expert has given his written consent that consent should not be withdrawn. Declaration related to above point that expert gave his consent and it is not withdrawn. Please write it down in your study material. Just mark a note and write down this point. This is the summary of this paragraph A that we are writing. Yes, Lahari Maruju, that is clear. Okay, I'm glad Nanda Goyal, it's clear to you now. Good. And everyone can write this point also. Okay, along with this, I'm going to explain you that point of certification also. So how can you certify that the correct and true copy has been given? So who will certify this translation? So if the translation is being done in India, then the certification will be done by advocate or judge of High Court, or an affidavit has to be taken by a person who is having the awareness of both the languages. So I just write it down for all of you again, this point. If translation is being done in India, this is related to your point of certified meaning. Certified, how it is, how the document needs to be certified. It is given somewhere in the study. I'll just show it to you also. If translation is done in India, I told you who will certify, tell me in the chat box. If translation is done in India, it will be certified by advocate or a judge of High Court. or by a person who is having knowledge of both the languages. What do you mean by both the languages? Means one, he is aware about language about English also, and he's also, if it is in French, he's also having the awareness of French also. So both the languages in bracket you can write down. One, the language of translation, like in French that you have translated in English, and second is English also. Second point is if translation is done outside India, then who will certify? Then who will certify? Only the person who has the custody of the original document. Then certified by the person who has the custody of original documents. मतलब जिसकी custody में ये documents हैं, only that person can certify. Then certified by the person who has the custody of original documents, or notary of that country. Notary of outside country person, either of them can certify. Anil Army is asking what type of documents. So the documents that we have been talking about when you were filing MOA and AOA under FC1 form, all those documents, remember, need to be certified and translated in English. Again, when we spoke about your filing of the documents, which needs to be converted into English language, your annual returns, financial statements, and profit and loss. So here we are understanding under section 386, where the word interpretation has been used, that it has to be certified. This is how it has to be certified, that where the translation is being done by an India, then by advocated judge of High Court or the person who is having good knowledge of both these languages. And if it is done outside India, then the person certified should be the person who has the custody of the original documents or the notarized person of that respective country. Is that clear? Now, section 389 talks about the registration of prospectus. No person will issue, distribute the prospectus when it is formed or will be formed unless the prospectus has been certified by the chairperson. Now it is talking about the registration. You have to get the prospectus registered. But first of all, the prospectus also needs to be certified. Who is going to certify? The prospectus will be certified by the chairperson of the company and two directors of the company, which are approved by the resolution of managing director. So chairperson will sign the prospectus, certify, and two directors, and states on the face of it that the copy has been delivered. Remember the last points of prospectus, it shall be written on the face of the prospectus that the copy has been delivered. Endorsed or attached, any consent related to section 388 shall also be attached. So this is how the registration of prospectus will be done, certified by the chairperson and two directors. On the face of it, it shall be written that it is delivered, and 388 also has to be compliant. Following documents shall be attached along with the prospectus. Let us read down. Consent to the issue of prospectus required by the expert. Contract copies of the managing director. Now, this is just the details. What else needs to be attached with the prospectus? Examiner can tell you there is a company incorporated in USA, opened up a business in UP. What all, and they're issuing prospectus. What all documents needs to be given to the registrar? Consent of the issue of prospectus by an expert. Contracts for the appointment of managing director or the manager. A memorandum means a statement related to the contracts. A copy of all the material contracts but entered within the previous 2 years. Within 2 years, whatever material contracts means not entered in the ordinary course of business. So you're into the shoe business, you're doing daily businesses, whatever business deals you have entered for the shoe business, not that, but any other material contract, anything else that you have done apart from your business, which is very important, that also needs to be given. Copy of underwriting agreements and power of attorney if prospectus is signed by an agent of director. So if director is signing the prospectus, then it is fine. But if director is saying, I will not sign, I have appointed an agent who is going to sign this prospectus, then POA of that agent is also required, that he has the authority to sign on behalf of the directors. So these are the simple points that you can remember, that these documents also needs to be registered when you are issuing the prospectus. We'll come back to ideas. Let me just complete the chapter first because ideas seems big, but it is very, very easy. Now, what is section 391? 391 says section 334 to section 36 of chapter 11, 20 are also applicable. So section 34 to 36, which are applicable for the misstatement of prospectus, civil liability, criminal liability, will also be applicable to the mutatis mutandis to the foreign company also. And chapter 20, that is chapter on the winding up, which is not part of your syllabus, will be applicable for the winding up of foreign. So if anyone asks you how the winding up of a foreign company will happen, chapter 22, chapter 20, which talks about the winding up of company, same way the business closure of the winding up of foreign company will be applicable. Section 392 is very, very important. Why we are not going to the presentation, why we are doing from here. So this is that we have done. Allotment of securities, section 388 is very important. Registration of prospectus, you can learn from this beautiful chart. It becomes very simple. Documents, these are the 5 documents that we have just discussed. Ideas, I told you, will be coming later on. So winding up provisions and section 34 to 36. Now, penalty for contravention 392 is important. Why it is important? Because you're coming from outside India, you're doing business in India, and then you're doing any kind of default, you'll be charged a heavy penalty. You're earning money in dollars. Your investment has come from there. So huge penalty will be required to be paid if you do any default. So any contravention done by foreign company, 1 lakh to 3 lakh rupees, first of all, the company will be charged. In case of the continuing default, rupees 50,000 per day after the first during which the contravention continues. So 50,000 per day, not a small amount. Earlier we have been doing 500 or 1,000 rupees per day. 50,000 rupees per day will be the additional default. And every defaulting officer of the foreign company, 25,000 to 5 lakh. Now, this is a very common penalty which you have been reading, 25,000 to 5 lakh. So it becomes easy for you to learn. So officer in default, OID, to 25,000 to 5 lakh. But the penalty of foreign company is very important. 1 lakh to 3 lakh rupees will be charged if you don't file your, if you have not complied with the provisions, if you have done any default in filing the prospectus, if you have not done the filing of FC1, FC2, FC4 form. So these kind of penalties, only this respective penalty only is applicable for section given under section 392 is applicable to the foreign company. Section 34, 36 for the misstatement in the prospectus and where 447 reference is given, there that you have to follow mutatis mutandis. That they have told you. Okay. So that is relevant here, section 34 and 36, where you're doing any misstatement, criminal liability and civil liability of prospectus. So whatever you have started over there, as it is applicable here. But for specific penalty for foreign company, children try to understand this. Section 392 is specific penalty for the foreign company. Foreign company is defaulting any of the provisions, then 1 lakh to 3 lakh is applicable. And how is the additional default? 50,000 rupees per day. Company's failure to comply with the provisions of this chapter will not affect the validity of the contracts. Very, very interesting topic as well as very, very important, something which requires understanding. So it says you are a company outside India, you have set up a business in India, so you become a foreign company. But if you do any failure, you're a foreign company, you do not comply with the provisions of this chapter, this is not going to invalidate my contract that I've entered with you. Section 393 says, government says that you have come to India and you have done certain contracts with us. Now, since you are a defaulter, it will not invalidate my contracts. My contracts will still remain valid and I can file a case against you. You cannot file a case against you. It says not affecting the validity of any contract, dealing or transaction entered by the company, its liability to be sued in respect thereof. So there is a foreign company, ABC Limited, it entered into a contract with Mr. J. So Mr. J, any contract that it has done for the transactions related to the company will remain valid, even if the company has done any of the failures. And what is ABC Limited cannot do? ABC Limited cannot file any case, cannot claim any set-off, cannot make any counterclaim. Even it cannot initiate any legal proceedings for any contracts until the company has complied with the provisions of Companies Act 2013. So unless and until you don't comply with the provisions of Companies Act 2013, you cannot take any action against Mr. J. But if you fail to comply, Mr. J can still file a suit against you. So if any foreign company complies with the provisions of Companies Act, then it can file a case against the contracts that it has made. Otherwise, if any foreign company fails to comply with the provisions of Companies Act 2013, then it cannot file a suit, it cannot claim a set-off, it cannot counterclaim, cannot initiate legal proceedings, but the other party can still file a case against it and the contracts will remain valid. It said not affecting the validity of the contract means the contract remains valid. Contract will still remain valid and third party can file a suit against the foreign company. Is that clear, everyone? 393 is clear to everyone, children. And the last section, 394, tells you that central government may exempt any foreign companies or the companies incorporated outside India, whether the company has or not established any place of business in India. Now, this is very interesting. Why it says foreign companies and why it says companies incorporated or to be incorporated outside India? What is the difference between A and B? Yes, Supriya, absolutely correct that you have written in the chat box. That is good. Abhishek Mishra, very good. Place of business, excellent. What else? Anybody can notice the difference between point A and B? Answer me. What is B then? Okay, A, everybody says foreign company is one which has an incorporated outside India having a place of business in India. What is the second one? Very good, Lahari Moruju. Second one is a body corporate. So any bodies, children, body corporate means any company which is formed in India or outside India or wherever in the world. Only if company formed outside India has a place of business in India, then it becomes foreign company, then this chapter is applicable. But body corporate can be any type of company. So if I ask you, can we say that all the provisions of foreign company are applicable to body corporates? Yes or no? Can we say all the provisions applicable to body corporate are always applicable to foreign companies? The answer is yes, because foreign company is always a body corporate. So all foreign companies are body corporates. Please write it down. All foreign companies are body corporates, but all body corporates are not foreign companies. Why? Why all body corporates are not foreign companies? Why? Because body corporates includes companies incorporated outside India and having a place of business outside India. Clear? Okay. So, foreign companies and body corporates may be exempted by central government related to the offering of securities, requirements of the prospectus, and all other matters related to IFSC centers in special economic zone. So it has only given one exemption till date, that is for IFSC unit, which my students have done earlier only while we were doing definition in section 2, clause 42. We have already understood this point. That is the last slide, that any unit that you have opened up in IFSC, you don't need to issue any prospectus or any other matters because foreign company provisions are not applicable to you. It will be treated as a company which is outside India only. There is no requirement of the chapter. So it is exempted. Exemptions is only for your IFSC unit. So now we are only left with the topic of ideas. We will complete ideas, then we will take the break for the question answers. Yes, Abhishek Mishra, that's correct. What about Ankit Mishra and other students who are sitting over here? Manoj Kumar, Ankit Mishra, I hope you all are understanding. Okay. So ideas and GDRs. So first of all, what is ideas? Till date, there has only been one Indian depository receipt, that is Standard Chartered, which came long back in India. But since this topic is given, we have already done the topic related to GDRs when we were doing chapter number 3, that is Prospectus, that is Global Depository Receipts. There we have understood how the foreign companies outside India are issuing the securities inside India. IDRs and ADRs talks about from here we are issuing the securities outside India and raising the money from there. So Indian depository receipts means any instrument in the form of receipt created by the domestic depository in India and authorized by a company incorporated outside India making an issue of such depositories. So let us understand with the help of example. There is a custodian bank in India. Say for example, HDFC Bank. And there is overseas depository bank. ABC. So a company, Indian company, let's take example Infosys, will go to HDFC Bank and tell them that I want to issue my shares or securities outside India. So this HDFC Bank will tell the overseas depository bank that I have received the depository receipts in India and which I'm going to give it to you. Now you can tell your company and you can issue the securities outside India. So how the two banks, the custodian banks and depository banks overseas are involved, and they exchange the information and details with each other, and company from here will approach their own local bank. That bank will inform the overseas bank and the securities will be raised over there. That is the depository receipts issued outside India. Similarly, global depository receipts, the people from there will give the information to their overseas depository. They will give the information to our local custodian banks and we will issue the securities in India. That is how the procedure we have to follow whenever any IDRs and GDRs are to be issued. So it says central government will make the rules regarding the offer of securities. Central government will make the rules applicable to the requirement of IDRs, disclosures which are required to be given in the prospectus, and how the IDRs are to be dealt by the depository, custodian or underwriter modes, how the transfer has to be happened by any company outside India, whether they have established or not any place of business in India. So it is talking about the body corporates. It is not talking about the foreign companies. It is talking about the body corporates. So any body corporate can issue the IDRs, but the only thing that you have to, in India, there is no depository banks. Nanda Goyal, how can you say that there is no depository banks in India? So in India, till now, only one Standard Chartered has issued the IDRs. IDRs have never come up in India after that. So that's why this topic is not very important. Okay, so you're right that domestic depository in India, that receipt which is created, it has only been done once, that is through Standard Chartered. But after that, it has not happened. But number of global depositories have come up in India. Foreign companies merge with the companies and they take approval from RBI and they try to issue the receipts inside India. So this topic is not very important, but yes, since you have done GDRs very well, so obviously it become important for you to just give it a reading. So if you have understood GDRs well, IDRs is similarly just the replicate of what that you are, just the reverse of that you have understood in GDRs. Okay, this is the requirement that has to be complied with. And this is how application of chapter 15, amalgamation arrangements, not very important for you. Is that correct? Simply remember two type of depository receipts. Banks are involved. They go a company will approach to the respective bank. They will inform the overseas depository banks and the receipts will be issued over there, which should be considered as the IDRs if you're issuing from here, and if you're issuing from there, then they will be issuing the depository receipts over there. All right. Now let us quickly see certain question answers also, MCQs. I hope you can do the MCQs with me. Okay, Jackson Communication LLC Incorporated in Arizona, USA has established a place of business in Kolkata, West Bengal. It is required to deliver the documents to the specified authority. You have to select the appropriate option, which indicates the number of days within which the requirements have to be submitted. Quickly tell me the answer, which is the correct one. Yes, Hardik, absolutely correct. When Indian companies issuing the shares outside India, it is ideas. When outside companies issuing the shares and receipts in India, that is the GDs. C is the correct answer. Absolutely correct. 30 days. So now you can see how interesting questions come in the exam. Just a click of button, you will be answering these MCQs and it becomes so simple for you if you have revised well. Morgan Stanley Digicables, incorporated in Berlin, Germany, established a place of business in Mumbai to do the business of data interchange and digital supply transactions online. It is a foreign company. It failed to deliver certain documents at the jurisdictional ROC, which is the jurisdictional ROC, Delhi ROC, within the time 30 days. Give the four options, correctly indicate the amount of fine which the company will be punishable. So what is the fine? Less than 50,000 rupees, which makes 10 to 5 lakhs, 1 lakh to 5 lakhs, 2 lakhs, or 1 lakh to 3 lakhs. So D is the correct answer. We have just done this question together. 1 lakh to 3 lakhs. And see, I told you this fine is very important and I'm sure it's going to come in the exam. Foreign company ka penalty is very, very important. Redix Healthcare, a company registered in Thailand and has no place of business in India. Okay. Yet it is engaged in the online business through detailed healthcare, remote healthcare. So online healthcare services if you're providing. Select the incorrect statement. It is very, very important to read the question carefully, children, in the exam. Select the incorrect statement in the light. Redix is not a foreign company as it has no place of business. It is a foreign company being involved. It is a foreign company. It is a foreign company. So which is the correct answer for the third one? Very good. So A is the correct answer. 5K Cosmetic Shop, a place incorporated in Switzerland, is involved in digital supply through electronic mode, the server of which is located outside India. So children, if server is located outside India, then it is not a foreign company now. Please tell me. If server is outside India, then it is not a foreign company. Yes? Approve say no, ma'am, then it is not. It is not relevant. Yes, that's correct. It is not relevant. Server may be in India or not India. That is not important. So it is, yes, it is a foreign company. Company follows the calendar year as the financial year. It is required to prepare P&L and balance sheet. Choose the correct timeline within which the documents. Again, it is how many days? 30 days, 3 months, 6 months, 60 days. It is 6 months. And can we extend this 6 months? Can we extend within how many months? 3 months. Very good, very good, very good. I feel so proud of all of you when you give such correct answers, and I really wish that you give such kind of correct answers in your exam also. So let's take a small break because there are huge questionnaire coming up for you. So quickly, I give you 10 minutes to just going a good amount of question answer discussion. Hardik, don't worry about ideas and GDS. After the break, I will just quickly go through this point again. Okay, not very important, but still we'll do it. Okay, don't worry. All right, welcome back, students. Now, all of you are going to do these question answers with me. I'll be reading out the question and everybody will be required to answer them. You will write down the answers in the chat box. A foreign company incorporated in Japan has a branch office in Hyderabad. Mr. Bhartiya, the Indian citizen, holds preference shares of Z, which consist of 10% of the paid up share capital. Desi Limited, a company incorporated in India, holds equity shares, which is 45% of the paid up share capital. During the financial year, there has been alteration in the documents mentioned under 380, and the company has failed to submit the alteration to the registrar within 30 days. In the light of the above application and consequences, explain the validity of the contracts entered into by the company. What do you think will be the applicable answer for this question? It's a descriptive based question. Just analyze the question carefully and try to give your answers in the chat box. Yes, it is a foreign company. That's good. All right, Supriya, definitely we'll plan for the revisionary batch for you people also. Not to worry, we'll definitely think about that. I've read your point and we'll take it into consideration. It is a foreign company as paid up share capital is more than 50%. That's good. Contract remains valid even if the company fails to comply with the provisions. It has to file MC2. Very good, Nanda Goel. Correct answers being given by you. Pallavi Jha, good. Whatever is your understanding, just express your points because you can't write the full answers. I can understand in the chat box. Kasak Yadav, excellent. Fees, I have not told you any fees as may prescribed. Remember 385, that is important, but here it is not about fees. Full Companies Act is applicable to the contracts, but is valid company cannot. Very good, Hardik, Dilip, Kasak Yadav. Excellent answers, trial done by you. Now let us see, because what is important is I want to tell you how you have to write your answers. First of all, 379, since it is more than 50%, if it is more than or not then you have to tell about this provision of the act it is being held by. Since it is mentioning that the Z Limited 10% and DC 45, so 55% of the shareholding is being done by Indian companies. So with regard to the Indian business, if 50% of holding is being done, then the applicability of the Companies Act will be applicable. 393 talks about if you fail to comply with the provisions that will not affect the validity of the contract, the section that we just did right now, that any counterclaim and other things company cannot do, but you can still file a suit. So the above questions, the Companies Act is applicable on Z Limited because it is 55% of the paid up share capital is being held by Indian citizen. Therefore, yes, the provisions of the Companies Act will apply. The first part is that provisions of the Companies Act are applicable. And now, since the violation has been done, validity of the contracts, it will not affect that the foreign company cannot file a suit, but the foreign company shall not be affected. The company may be sued in respect of such contract, but will not be entitled to bring any suit until it has complied with the provisions. So since the provisions are here, you don't have to talk about penalty, Nanda Goel. You can write about these, but otherwise it is specifically asking you about the applicability of the contracts. So this question 100% relates to section 393 only, validity of the contracts that we have done. But since it has given the application of 379, so both these sections will be applicable to this respective question. All right, and remember to underline your answers. That is how, and divide it into different paragraphs. Don't write whole big essays on the exam. Divide it into paragraphs and try to explain to the exam. Now, this is very interesting question. Mr. Zian, an Indian citizen, holds 25% of the paid up share capital of Laurel Steven Limited, a company incorporated in Singapore having a paid up capital of 10 million Singapore dollars. Swaraj Limited, a company registered in India, holds 30% and it has recently established a share transfer office in New Delhi. What formalities does it need to observe as a foreign company? So please tell me whether it is a foreign company, what is the application? Whenever it is writing about the Indian citizen holding, so you have to pick up this point, then obviously it will be talking about 379 because it is talking about the percentage of the shareholding. So you give the definition. 386, place of business includes share transfer. We have just done that share transfer is also, so Lawrence Serville is also a foreign company. So 379 talks about the 50% of the shareholding. In this case, Laurel Civil is operated in Singapore and having a share transfer office in India, so it is a foreign company. Since the shareholding are being held by Indian citizen and 30% by Indian company, together they are holding 55%. Therefore, it is also a foreign company, and due to holding of more than two entities, 379 will be incorporated and will be treated as company incorporated in India. Companies Act will be applicable only with respect to business carried on in India and not relation to anywhere in outside India. Now, this is very, very important line why I have highlighted for all of you is only for the Indian business that you're doing whole of the Companies Act is applicable, and not if this company is having 10, 12 more subsidiaries. 50% of the shareholding is anyways making you a subsidiary company, right? So if you're having more than these any other countries, then it is not applicable. It is only applicable with respect to the Indian business. Foreign company is required to file the registration. ROC with one, FC1 has to be filed, and all the documents you have to mention what are required to be filed. The FC1. List of the directors, secretaries, everything will be given. All right. Good. Okay, one more we can do again. This is related to 379 and 380 only. So maybe we can skip this one. Yes, this is that question that I have made you write down. Quengi Hyundai Industrial Company Limited, incorporated in China, established a place of business in Mumbai. The documents constituting the company is Mandarin, Chinese local language. It required inter alia filing certified translation of the above documents. So I told you when you're filing the documents with ROC, you have to get them certified, authenticated. Who can authenticate the documents as per the provisions of Companies Act, and while governing the foreign companies, in such translation is made in Mumbai. So according to Rule 10, so which I have made you written down, so you can write down this Rule 10, you can give it a certification. All the documents to be filed with ROC are to be in English language, and if it is not in English language, you translate it. If it is the translation is done in India, advocate attorney of High Court will do it. Affidavit for the person who is having, in the opinion of registrar, is aware of both the languages. Since the company can translate it within India, they can get it authenticated from these persons. And what if it is outside India? If the translation happens outside India, then I told you notarized person of that country or the person who is having the custody of these original documents. Is that clear? Can you relate this point, children? Everyone is clear? Yes. Good. Ajay Surya, Hardik Tambeshwari, Nanda Goel. Very good. All of you have given the correct answers. Good. Good, Neeru. I'm glad everything is clear. Supriya, great. Okay. Let's do one more question. Since you're employing agent, cloud computing, this we have done. Now you know about these kind of things. Okay, let's do this. X Inc. is a company registered in UK and carrying on any trading activity with the principal place of business in Chennai. Since the company has not obtained the registration or make arrangements to file the return, GST intends to showcase the notice on foreign company. Advise the GST servicer on the service of the notice, how the notice has to be served. How will you serve the notice? Since it's a foreign company, servicing of any documents have to be done to the authorized person who is named in the whose name and address has been delivered to the registrar. It will be left at sent by post or the address by the electronic mode. Therefore, it will be served following these provisions. Again, similar question 383 as it is service of documents. 3 marks question has come in the exam. Very good. All of you are understanding and writing the answers. I'm so proud of you. Okay, let me see which one we can do one more. Oh, this is nice. A company incorporated in Singapore, Vibhav PTE, having a license office in Delhi, they seeks your advice on the documents to be filed with the registrar for the financial statements. So you will write all the annual accounts prepared as per Schedule 3, related party transaction, repatriation, transfer of funds shall be included. Okay. You want to do more questions, children? Hardik, we are doing all these questions in the class. You can take a note of them, and still I will try to upload also, and all the presentations have been uploaded. This incorporation outside India also, I will upload this presentation. Okay. Phil Health Systems Incorporated, a foreign company registered outside India. It is having a place of business in India. It prepared the financial statements according to the. Okay, this is the answer. I'm so sorry. I'm reading the answers out. Whether the accounts of the company pertaining to Indian operations are to be audited. Yes. So you will reply Chapter 10, Mutatis Mutandis is applicable by a chartered accountant in India or a firm or LLP will be doing that. What is the due date of this? So this question is related to your auditing. I told you, no, they can ask you a foreign company and how the audit has to be done. What is the effect of the control contract centered? IDR ka aaya hi nahi hai, Dambeshwari. They haven't asked you any question related to IDR. Okay. Okay, Nanda Goel. What is the effect of the contract entered, which has not been filed? So again, it is asking about the contracts. Non-filing of the contracts will not invalidate the things. And company will prepare annual return. Now you have to answer me. What are the provisions related to annual return? Was there any provision that you have done related to annual return? Within how many time, within how many days the annual return filing has to be done? Very good. All of you have given the correct answer. Within 60 days, FC4 has to be filed. Within 6 months? No, within 60 days, annual return has to be filed. Okay, now as promised and as discussed, I told you we'll talk about the R's and DDRs are not very important. I'm telling you repetitively. And all these descriptive questions, children. Now, when I've discussed these questions with you, just sit at home and relax and see all these questions. They're all related questions. So just pick it up from here and paste it over there so that you're able to answer me directly rather than cheating it out from here. And this Redstone Zen Limited we have done in the last class also. So try solving these questions by yourself, write down the answers, handwritten answers by yourself, and then try to compare what the answers are giving in the study material. Then you will be able to learn it and retain the information. Now, when Indian company is raising the funds from public issue and it needs more money, so we go to overseas and we raise the funds. Okay, so that is your ideas what we were discussing about. I told you it is not very important, but since many of you are raising a doubt, I'll explain you with the help of example. Say, for example, there is an American boy, Mr. John. He's an investor. He wants to buy the shares from the Indian company. So that is your about GDR, section 41 that I've done with you in chapter number 3. So how will he issue the money? He will go to the overseas bank over there, overseas depository bank, and the company will go to the overseas depository bank and they will tell them that, okay, fine, these are the receipts which we want to raise to the people sitting in India. We want to raise the securities to out to them over there. So that is how your global depository receipts is reaching over here. Now, first, the bank will have to go to each other's custodian. The Indian company will go to their Indian custodian banks and the US company will go to their overseas depository banks. So both the banks will be having a relationship among with each other, and that is how the way we are issuing the securities at the stock exchange. But before going to the stock exchange, they will tell them that we have got the receipts over here. Now you can issue the securities to them. So that is how the whole procedure has to be followed. But any questions related to this, I have not seen so far. And but anything can come in the exam. We cannot stop for that. So this manner of 4 points and keeping in mind your local custodian banks and overseas depository banks, that is one thing that you can keep in your mind and you can remember and retain this information. All right. So you can just keep in your mind that Infosys wants to raise money from US. How will they do it? They go to the HDFC bank. HDFC bank will tell to overseas depositories, okay, now you issue the receipts, we will receive the money. That is a simple thing that you can remember in your mind to retain this information. All right. So thank you very much, students. I hope you have enjoyed the session and you have understood each and everything. We have covered almost full chapter of foreign companies. All the doubts have been taken up. Still, you have any doubts, you want to ask anything, you want to speak, you can raise your hands, you can ask if you have any doubts. But otherwise, thank you so much, Rathi Milani. I'm glad you have understood everything. And we are done with the session and well in time we have completed. Thank you, Nanda Goel. I'm glad all your doubts are cleared. Hardik says you have understood. I'm glad. That's nice. Thank you, Neeru. Thank you so much, children. Thank you, all of you. So if you don't have any doubts, thank you so much, Beta, Rati Milani, Kasak Yadav, Pallavi, Neeru. Thank you, children. And we'll be meeting soon for FEMA session. I'll be meeting you now. So till then, all the best. Remaining chapters. Yes, Manvi, I'll be meeting you for FEMA now. Thank you, Dilip. Hardik, I'll be coming for the FEMA session and that we'll discuss. Thank you, Supriya. Thank you, Manvi. Yes, Nanda Goel. Thank you so much, Beta. All right. So if you don't have any doubts, then we can wind up the session, children. Okay. All right. Yes, sir. We have completed the syllabus. It's over. Yes. Okay. Thank you.